Heyo! Welcome to Monday. And today, officially, is trial day 41. But they haven't started yet. I already know that. And so we will do recap of day 40 until day 41 starts. What else do I have in mind? Yeah. For you who don't know, in August, I will be traveling to the United States. I will visit Houston for the Matsuri, and then I will take a road trip from Houston to Michigan via Atlanta and Delphi. So if you are on one of my stops, Houston, South Coast, up to Atlanta, then up to Delphi and up to Michigan, give me a holler, have a meetup. And Atlanta will be around August 14. And I assume this trial will still be ongoing, and I will be trying to get an interview with one or a few of the lawyers, or get into the courtroom. That is what I will try, at least. So, and I will, of course, record every bit. I will record a lot of it of that road trip to transmit to you all. So August, I will land August 7th and in Houston, and I will be traveling back August 20th or 21st, and I will be taking off from Michigan. So that is some of the plans going forward. Then also in May 10th, I'm having my birthday stream. So don't miss out on that. Yeah. Okay. But we are here. Recap day 40 of the Young Thug trial. Yeah, day 40. Of course, Mr. Judge Glanville, late as per usual. Even though it was a short day, he was still late as per usual. Day 41, as in today, he's told the jurors to be there 10:30 a.m. for an expected trial start 11 a.m. So we have at least an hour of recap of day 40. Because, as we all know, the judge is always late. But let's listen to this.
All right, thank you, Deputy Smothers. Ladies and gentlemen, please be seated. Ladies and gentlemen, jury, good morning.
Good morning.
All right, sound good. I'm sorry we're kind of a little bit of a delay. You know, weather tends to make people lose their minds in Atlanta, especially when it comes to traffic. I understand a couple of you delayed, not a problem. So we're going to continue with examination of our current witness. Mr. Bean, you still under oath, okay? Sir, still under oath?
Yes, sir.
Okay, good. All right.
Good morning, Mr. Bean.
Come on.
When we left off,
Take a wild guess. This is still the prosecution's direct. Take a wild guess on how he's going to answer most questions.
yesterday, I was asking you what you remember about a time in 2013 in September, speaking with an Atlanta police detective at Atlanta Police Headquarters. I want to pick up with that, okay?
Yes, ma'am.
All right. Do you recall during an interview in September 2013 at the Atlanta Police Headquarters, a police detective asking you what Big Fred's deal was for that job?
I don't recall, ma'am.
Do you recall telling that same detective or a detective in September 2013 that Big Fred had taken hold of the 9mm Ruger in the car that you all were in?
No, ma'am.
Do you remember telling a detective with the Atlanta Police Department that Big Fred was just trying to put something in his pocket, just trying to get out? Do you remember that?
No, ma'am.
Do you remember speaking to a detective about September 11, 2013 at Atlanta Police Headquarters and saying, at the time we went in Summerdale, the robbery wasn't no robbery because he could have gotten out. Thug could have gotten out.
No, ma'am.
Do you remember telling a detective at the Atlanta Police Department that DK could have gotten out? They could have went on there and had their business.
No, ma'am.
Do you recall telling an Atlanta police detective in September 2013, Thug tells DK, he didn't really just.
Yeah, what the prosecution is doing here is she is more or less reading directly from this officer Quinn's report. That's what she's doing. And does it in form of questions? She did that. She started on day 38, continued the entire day of, I mean, yeah. And I understand the tactics. I don't think it's necessary at all. Because we already know that at least one of the officers who was involved in this robbery actively erased recordings because he did not get the answer he wanted, so he deleted recordings. We also know that a bunch of officers lied on the stand regarding a surveillance video. We heard on the traffic radio traffic recording that officers were watching the surveillance video. So I guess they are doing they might as well do this to try to hide everything, but I assume the defense, I can't wait for the defense case in chief regarding this. I really can't wait. I don't know when it will start, because I would assume we will be here at least June, July, maybe even August with the state's case in chief.
Say, go get the money. He was like, go get it. Go ahead and get it. Go get it. Do you remember telling him that?
No, ma'am.
Do you remember Detective Quinn asking you during a September 2013 interview at the Atlanta Police Headquarters whether you knew that they were going to take Dirty Red's money?
No, ma'am.
Do you remember Detective Quinn asking you at Atlanta Police Headquarters in September 2013, was there a girl in the car anywhere?
No, ma'am.
Do you remember telling Detective Quinn there was no girl?
No, ma'am.
Do you remember Detective Quinn asking you, are you just trying to hide that from your wife? There's no girl in the car anywhere?
No, ma'am.
Do you remember telling Detective Quinn, no girl, there wasn't no girl in the car. The girl they think is a girl, the girl they think is a girl is Thug, man. I gave it to Thug, man. Thug got the wild hair. Do you remember telling Detective Quinn that?
No, ma'am. I don't have it. No, ma'am.
Okay. Do you remember telling Detective Quinn it's over 180 of these little motherfuckers and that you ain't trying to get in conflict? You're a family man?
No, ma'am.
Do you remember Detective Quinn asking you in September 2013, where's Thug sitting, up front or in the back?
No, ma'am.
Do you remember telling Detective Quinn he's in the back with DK?
Remember the photo from that car? The amount of trash and tools and a toolbox in the back seat? Yeah, I don't think so. I think this guy at the time tried to put blame on everything else. And now it comes back to bite him. And for me, it's obvious, completely obvious, that he at that time tried to put a fast one on that officer. And Mr. Bean, a few years later, recanted everything about any involvement regarding Mr. Williams. So,
No, ma'am.
Do you remember Detective Quinn asking you, wait a minute, who's up front with you?
No, ma'am.
Do you remember telling Detective Quinn that up front, you got me, meaning yourself, and Big
culparistic. I feel there should be an objection. I think the defense have objected several times in the beginning of this, but the judge don't care, as per usual. And so this is her testifying about what is in the report written by Detective Quinn. Here's the thing with Detective Quinn. If he is one of the he actively denies, and he will probably do so during once he gets on the stand, if he ever gets on the stand. I have no clue that he had no idea about the surveillance video, which in my book puts him in the column of bad cop.
Fred.
No, ma'am.
Do you remember telling Detective Quinn that you were driving?
No, ma'am.
Big Fred was on the passenger seat. Thug was behind Big Fred, and DK was behind the driver. That's you.
No, ma'am.
Do you remember Detective Quinn asking you again, who's behind Big Fred?
No, ma'am.
Do you remember telling Detective Quinn Thug was behind Big Fred?
No, ma'am.
Do you remember Detective Quinn asking you about who shot DK and who shot Big Fred?
My statement is that I don't remember anything from 2013, ma'am.
Okay, I understand, but I have to ask you these questions, okay?
No, you don't, ma'am. No, you don't. She actually don't have to do anything. You know what she could do? She could dismiss. She could go up to the judge. We really don't have anything. I'm so sorry for wasting everybody's time and millions of taxpayers' money. Let's just walk out of here. That is what she can do, but she won't. Same with this questioning of him. She can choose to not do it. She chooses. She don't have to do anything.
Do you remember telling a detective at the Atlanta Police Department that you thought Big Fred was shot in the back?
Your Honor, object. Basis. The witness is asked and answered. Overruled. Anything else? No, Your Honor. Okay. Basis.
Foundation, I'm going to ask that they establish what they stated was that they're referring to.
They've already established that. That was one of the first questions they asked him. So I'm over your objection. Okay. All right.
I'm not entirely sure. I mean, if his ruling at the beginning of this was overruled due to him claiming he doesn't remember, and that's the judge's ruling, and it's in his discretion. I think it's flawed, but it's still in his discretion, as in everything else regarding this trial. Allowing the prosecution to extend the witness list from 300 to 771, allowing the prosecution to get evidence in they claim they found during trial and stuff like that. For me, it's appalling. The moment the prosecution says we are ready for trial, in my opinion, unless it's actually completely new evidence, you're done. That's what you have to bring to trial. Now, I know it's not, that's never going to happen, but it should be that way.
Do you remember, you may answer this question if you can, and whatever answer that is. Do you remember telling a police detective during a September 2013 interview at the Atlanta Police Department that you thought Big Fred was shot in the back?
No, ma'am.
Do you remember a detective asking you whether or not someone from the back could have shot Big Fred?
No, ma'am.
Do you remember telling the detective at the Atlanta Police Department, a detective, in September 2013, that you couldn't say whether Thug or
If that is the answer Detective Quinn claims he got from him, I assume it was after allegedly speculation after he told Mr. Bean, don't you get in trouble, because I honestly believe that the gunshot that hit the person came from a cop, and it was probably a bad shooting.
DK or either of them shot Big Fred in the back.
No, ma'am.
Do you remember a detective at the Atlanta Police Department in September 2013 asking you how many shots did you hear in the car when it was crashing over the wall?
No, ma'am.
Do you remember telling the detective you heard one shot, but you couldn't say it was a shot because there was so much confusion?
No, ma'am.
Do you remember telling a detective at the Atlanta Police Department in September 2013, I know DK couldn't have shot him because he was more worried about, is he okay? He's more worried about his situation, because he had to run. Do you remember telling a detective at Atlanta Police Department that?
No, ma'am.
Do you remember telling a detective in a September 2013 interview at the Atlanta Police Department that
I
Dirty
agree,
Red
Heather.
ran?
But judge allows it.
No, ma'am.
And with that, it's not much we can do, or the defense can do.
Do you remember telling the detective or a detective at the Atlanta Police Department in September 2013 that you, Mr. Bean, did not rob anybody?
No, ma'am.
Do you remember a detective, specifically Detective Quinn, during a September 2013 interview, telling you, asking
Objection.
you about the name of the person with the DK tattoo on his forehead, the backwards K?
No, ma'am. I don't answer that.
Do you remember a detective telling you in September 2013 during an interview at the Atlanta Police Department, I don't know the guy's real name that had the D in the backwards
Objection. Hearsay.
K on his forehead, but I'm going to see if I can find it?
No, ma'am.
Do you remember the detective or a detective at the Atlanta Police Department asking you, why'd you wait on DK after he was shooting? Why didn't you just leave him?
No, ma'am.
Do you remember saying to a detective during an interview at the Atlanta Police Department in September 2013 that you were pissed off with DK?
No, ma'am.
During September 2013, did you have a Camry?
Yeah. Queen telling you. I think that was a Freudian slip there. I assume if they don't have an actual recording of it, that it's just a transcript or Detective Quinn's report, that he more or less told Mr. Bean how to answer. Nothing surprises me regarding the Atlanta Police Department and some of the cops and what they are willing to do to either cover their own asses or to frame people.
That you were driving?
No, ma'am.
Do you remember a detective asking you whether Thug was in your black Camry earlier when he went to check on that lick?
No, ma'am.
Do you remember telling a detective in September 2013 that no, Thug wasn't in your black Camry earlier when he went to check on the lick?
No, ma'am.
Do you remember a detective in 2013, September, at the Atlanta Police Department, asking you when Thug went up to Ken's shop, was he using your car or another black Camry? Do you remember a detective asking you that?
No, ma'am.
Do you remember telling a detective in a September 2013 interview at the Atlanta Police Department, Thug got a black Challenger?
No, ma'am.
Do you remember a detective, specifically Detective Quinn, asking you during an interview in September 2013 whether Thug?
All right. I have 5 memberships to gift every month. 10 to gift. I can give 5 per stream. And I just did that. Those are free for you. And so you're welcome. It went to Heather Mosher, Culperistic, Nokur San, Rose Sevener, and Benjamin Gray. Congratulations. You now have access to all of my members-only content. And you also have access to my Discord via a link in the community section on YouTube. Okay. Yay. Now, if somebody is gifting memberships, you can allow that by pressing on top of the chat. You see where I gifted 5. Press that, and then you can get the option of allowing gifted memberships if somebody else does it. Or you can choose to pay $3 a month yourself. All right. Let's continue with this ribbit. I forgot the word I was supposed to say. Let's just go on.
Had his own car.
No, ma'am.
Do you remember responding to a question about Thug having his own car? Thug has a black Challenger.
No, ma'am.
Do you remember a detective in September 2013 asking you, when did you first see the uniformed police officer that fired the gun, or whether or not you even saw it?
No, ma'am.
Do you remember telling a detective in a September 2013 interview at the Atlanta Police Department, man, I don't even remember the police getting there?
No, ma'am.
Do you remember Detective Quinn asking you in a September 2013 interview, did you ever hear the police give a command?
That's the word I was looking for. Thank you, Gigi.
No, ma'am.
Do you remember Detective Quinn
Riveting
asking
testimony.
you, did you see a police officer?
No, ma'am.
Do you remember telling Detective Quinn that you did not see a police officer?
No, ma'am. I don't remember.
You do not?
I don't remember.
Do you remember a detective asking you in a September 2013 interview, did you knowingly ram the cop's vehicle trying to leave? Did you know you hit it?
No, ma'am.
And do you remember telling a detective in a September 2013 interview that no, you didn't knowingly ram a cop's vehicle while trying to leave Summerhill?
No, ma'am.
Do you remember telling a detective in a September 2013 interview that it was the cop that bumped you?
No, ma'am.
Do you remember a detective, specifically Detective Quinn, asking you during a September 2013 interview whether it was fair to say that the cops tried to block you in to stop you from leaving?
I'm speeding
No,
up
ma'am.
to 1.5.
Do you remember Detective Quinn asking you in a September 2013 interview, why didn't you stop when you saw the car that the police were in?
No, ma'am.
Do you remember telling Detective Quinn in a September 2013 interview, you didn't know it was a cop because you did not see a uniformed cop?
No, ma'am.
Do you remember Detective Quinn or any other detective at the Atlanta Police Department asking you in a September 2013 interview, who'd you see in the car that pulled in front of your car? Y'all are nose to nose. Do you remember Detective Quinn or any?
Nokur San says, if defense do cross, we will be in for another round of redirect asking all this over again, assuming the judge will overrule asked and answered objections. Here's the thing. I think that, the prosecution did this Friday. They kept this all up until the end of the day to have the jury think about it all weekend. I think cross-examinations of this guy will either be non-existent because they don't want to have just don't want to, or they will cross-examine him up until the end of day, because after today, they won't have trial day until next Tuesday. So they will have March 5th to March 11th off. So it's one of them, either no questions or try to extend their cross-examination to the end of today. And today is only a half day. Day 41 is only a half day.
Any other detective asking you that?
No, ma'am.
Do you remember telling Detective Quinn that you saw 2 females and that was all you saw?
No, ma'am.
Do you remember Detective Quinn asking you whether you were running from two females?
No, ma'am.
Jules, thank you for your $2 super chat. Can we just skip to the cross now? Brain hurts. They haven't started today yet. Let's see here. Okay, the stream is live, I see. But they haven't actually started yet. So, yeah. So we will keep this. I know we will keep this until I see. Okay, now they have started. Then I will skip to the end. We'll listen a few minutes to that, and then we will go directly over to day 41. Thank you so much again, Jules.
Do you remember Detective Quinn asking you whether you thought maybe the two females were cops?
No, ma'am.
Do you remember telling Detective Quinn that you were thinking that maybe when the car stops that the two females were in, you didn't know whether they were going to one of the buildings or what was going on, but you knew that you were going to go around them?
No, ma'am.
Do you recall Detective Quinn asking you in a September 2013 interview, did you think the two females were trying to stop you from leaving the scene where the gunfire was?
No, ma'am.
Do you remember telling Detective Quinn that you thought you were going around a car that's still moving and this car just hit all of a sudden?
What's interesting here is she shifts between Detective Quinn and a detective, which means there should be more than one asking him questions, as in alternating in an interview room. There should be a recording of all of this. So it should be, does this recollection refresh your recollection, and then play some of that. And I'm not entirely sure why they don't. My guess is they don't have video of his alleged confession. And so she has to, and rely on whatever documentation she has. Do Jody rule apply to this direct examination? Oh, that would be amazing, but no. We are currently waiting for the day 41 to start. Then I will play the last couple of minutes of this day of day 40, and then we will move on to day 41. And day 41 begins with cross-examination, if there is one.
No, ma'am.
Do you remember telling Detective Quinn during a September 2013 interview when asked, did you hear any commands? I ain't hearing no freeze, get out, let me see your hands. I heard none of that. Do you remember saying that?
No, ma'am.
Do you remember telling Detective Quinn during a September 2013 interview, I ain't heard no shots go off by no police officer?
No, ma'am.
Do you remember Detective Quinn asking you whether anybody in the car with you mentioned that the two females were the police?
No, ma'am.
Do you remember Detective Quinn asking you whether out of all four people, or the three others besides yourself in the car, whether either one of them ever said anything about the police?
No, ma'am.
Do you remember telling Detective Quinn neither Big Fred nor anybody else said anything? There was a 12 shot or anything like that. Do you remember saying something like that during an interview with the police in September 2013?
No, ma'am.
Yes, please hit that thumbs up. It really helps the channel, and it shows that you actually like what I'm doing. I know this is not the most interesting testimony. He's been saying this for 2 days. But I think I deserve it, don't you? I think I deserve your thumbs up. Or thumbs down, if you don't like it. You're more than welcome to bring constructive criticism.
Do you remember Detective Quinn asking you in a September 2013 interview about you all having gone through the yard, having hit all those tricycles, and that there could have been kids on those bikes?
No, ma'am.
Do you remember telling Detective Quinn that you could have lost your own life?
No, ma'am.
Do you remember Detective Quinn telling you during the September 2013 interview that you all cleared a police car back under the wall and just missed it?
No, ma'am.
Do you recall Detective Quinn asking you about a phone call with your wife wherein you said, why did I get involved with those young motherfuckers over and over again?
I don't recall, ma'am.
Yeah. Diane Lochetto, either his selective amnesia or his fearful for his life, or a combination of both. According to some testimony, or his own at least, he did a crap ton of drugs back then. So after he got out of prison in 2017, he left everything behind him. And that was 7 years ago. The human mind can do very interesting things to you, especially on drugs. And but I do think he knows what he said back then, and he really don't want to do anything at this trial. Maybe fearful, or just that, screw you, lady. I already did my time for this. I'm not giving you shit. So it could be that also. And then he's still, what amazes me, he is still married to the woman he married back in, he's been married for 20 years or something, have adult kids with that woman, and they are still together. That's impressive. That's honestly really impressive. And he might not want to risk anything in this trial as well. He might just want to say F you to the prosecution, and with this, please don't come after me to the defendants.
Do you recall telling Detective Quinn that the people in the car with you were gangbangers, but that you don't gangbang?
No, ma'am.
I need to fill
Do
up
you remember
my
Detective Quinn telling you that he had to
coffee.
go talk
I'll be right
to the
back.
people that were in the car with you again?
No objection. Basis hearsay in approach. Okay.
Oh, look at that. That brings us to sidebar counter 101. Oh, 101 sidebars. 101 sidebars. This we can skip through. Oh, it's a long one.
Do you recall Detective Quinn asking you or speaking to you and telling you that he needed to go find a picture of the person you were calling Thug?
No, ma'am.
Do you recall expressing concern about Detective Quinn putting you on blast?
No, ma'am.
Do you recall telling Detective Quinn that putting you on blast would make things difficult for you?
No, ma'am.
Do you remember talking to Detective Quinn about going to jail and telling your wife what went on?
No, ma'am.
Do you recall telling Detective Quinn, do you recall Detective Quinn asking you, how does that work on the street? If it's their move, do they get more money than you, or do they get the same? Do you recall Detective Quinn asking you that?
No, ma'am.
Do you recall telling Detective Quinn that it was DK's and Thug's move?
No, ma'am.
Do you recall telling Detective Quinn that everyone in the car was probably going to split the proceeds of the robbery evenly?
No, ma'am.
Do you recall telling Detective Quinn in the Atlanta Police Department in September 2013 that you had been robbed 4 times in 2013?
No, ma'am.
Do you recall Detective Quinn asking you whether you knew who the persons that robbed you were?
No, ma'am.
Do you recall telling Detective Quinn that you were not going to tell him who robbed you?
I don't recall.
Do you recall telling Detective Quinn that it is what it is? We out hustling in these streets. You can't pick up the phone and call the police and tell the police I got robbed. Do you recall telling Detective Quinn that during a September 2013 interview?
I don't recall, ma'am.
Spin the wheel. Time for hot sauce. I didn't plan to have one of these days today, and I have work tomorrow. So the wheel of regrets. Save it to Friday. I will save that for Friday because I'm doing a fundraiser on Friday with the wheel of regrets. So, but thank you so much. And if let's see here, stop, bum, bum, bum. What I can do is, I'm having a beer. I'm having a beer at least, which incidentally was close by. Yeah, I have a beer. Thank you, John. Thank you so much. I appreciate you.
Do you recall Detective Quinn asking you, why didn't you call it off? Even though you weren't sure whether the people in the car, the females in the car were cops, why didn't you call it off?
No, ma'am.
Do you recall telling Detective Quinn that you didn't know that they were cops in the car in response to the question I just asked you about in September 2013?
No, ma'am.
Do you recall Detective Quinn asking you who went in the gate first, you or the Taurus?
No, ma'am.
Do you recall telling Detective Quinn during a September 2013 interview that the Taurus was in the gate first?
No, ma'am.
Do you recall telling Detective Quinn that you were behind the Taurus?
No, ma'am.
Do you recall telling Detective Quinn that the Taurus went straight back in the back of the cars?
No, ma'am.
Do you recall Detective Quinn asking you how long was it before the Taurus showed back up in that scene where the gunfire happened?
No, ma'am.
Do you recall telling Detective Quinn, what did I say? Man, DK started shooting at that cop.
No, ma'am.
Do you recall Detective Quinn telling you that had DK not started shooting and just robbed Dirty Red, the police would have never known what was up?
No, ma'am.
Do you recall Detective Quinn asking you whether Dirty Red was robbing you all, whether he was trying to rob you all who were in the car?
No, ma'am.
Do you recall telling Detective Quinn, no? Are you saying Red robbed us?
No, ma'am.
Do you recall telling Detective Quinn during a September 2013 interview that you and Dirty Red go way back and that you used to go to his mom's house?
No, ma'am.
Do you recall telling Detective Quinn that you didn't realize it was Dirty Red that they were about to do the move on?
No, ma'am.
Do you recall telling Detective Quinn that if you had known it was Dirty Red, the robbery would have never happened anyway?
No, ma'am.
Do you recall telling Detective Quinn you knew that the person they were going to rob was Red, but if you had seen the real Red, if you had seen him running, you'd have told him, hold up, and told DK, you tripping, these are my people, these are my people.
No, ma'am.
Is there a Dirty Red that you considered your people back in September 2013?
No, ma'am.
Do you recall Detective Quinn asking you whether you thought it was another Red who had that check?
No, ma'am.
Do you recall telling Detective Quinn during a September 2013 interview that, yes, sir, you thought it was another Red who had the check, who had the money?
No, ma'am.
Do you recall telling Detective Quinn in a September 2013 interview that you know the deal with your folks?
No, ma'am.
Do you recall Detective Quinn asking you, are they a gang? What gang are they?
No, ma'am.
Do you recall Detective Quinn asking you whether you know where Dirty Red lives?
No, ma'am.
Hi, Sal. Good to have you here.
Do you
Welcome
recall
to this riveting
talking to
testimony.
Detective Quinn about an apartment, which Detective Quinn asked you about it being a trap?
I don't recall.
Do you recall telling Detective Quinn that you knew that Red didn't live in the apartments you all were talking about, but that you knew his mom?
I don't recall.
Do you recall Detective Quinn asking you more than once whether Dirty Red pulled out on you all, meaning you, DK, Thug, and Big Fred, and tried to rob you all?
I don't recall, ma'am.
Do you recall telling Detective Quinn, no, sir, he did not? That is, Dirty Red did not try to rob me, Thug, DK, and Big Fred.
No, ma'am.
Do you recall Detective Quinn telling you, let me go see if I can find this picture of this boy with the crazy hair that I guess looks like a girl?
No, ma'am.
Do you recall telling Detective Quinn, I gave you everything?
No, ma'am.
Do you recall Detective Quinn asking you if the guy with the crazy hair had the name Jeff?
No, ma'am.
Do you recall telling Detective Quinn, yes, the guy with crazy hair that made him look like a girl is named Jeff?
No, ma'am.
Do you recall Detective Quinn playing you a jail call wherein you spoke with someone asking you, what girl are they talking about?
And the World of Doom. I don't know why it shows up, because I have so much buffered. I've done everything on my end. I assume it is something between StreamYard and the YouTubes. Otherwise, I have no idea.
No, ma'am.
Do you recall during an interview in September 2013 with Detective Quinn at the Atlanta Police Headquarters, Detective Quinn allowing you to use the restroom and things of that nature?
No, ma'am.
Do you smoke cigarettes?
No, ma'am.
Did you smoke cigarettes in 2013?
I don't recall, ma'am.
Do you recall Detective Quinn asking you how long you've known Thug?
No, ma'am.
Do you recall Detective Quinn asking you, you said you knew his daddy, right?
No, ma'am.
Do you recall telling Detective Quinn in September 2013, I've been knowing his daddy since the football field, a while, like a couple of years ago?
No, ma'am.
Do you remember Detective Quinn asking you whether he used to play football?
No, ma'am.
Do you remember telling Detective Quinn that you knew Thug's dad is close to his son 2 years ago?
No, ma'am.
Do you remember talking to Detective Quinn about a center, reparation center on Cleveland Avenue?
No, ma'am.
Still waiting for day 41 to start. So Judge is now 15 minutes late. I assume he will be at
Do you
least half an hour
recall
late,
Detective
as
Quinn
per usual.
asking you whether or not the people who were with you knew that it would be Red, and that that Detective Quinn had not yet spoken to Red and didn't yet know what was up?
No, ma'am.
Do you recall Detective Quinn asking you during a September 2013 interview that he had to show a reason why the situation happened?
No, ma'am.
Do you recall asking Detective Quinn, how are you charged with something that happened to Dirty Red?
No, ma'am.
Do you recall telling Detective Quinn that you had given him the real story?
No, ma'am.
Do you recall telling Detective Quinn that the other guys in the car with you weren't going to tell you anything about Thug?
No, ma'am.
Do you recall telling Detective Quinn during a September 2013 interview that had you seen and known that the women were police, you would have stopped?
No, ma'am.
Do you remember telling Detective Quinn during a September 2013 interview that if you had seen the police and all of those police were involved, you would have actually stopped right there?
No, ma'am.
Do you recall Detective Quinn asking you, who did you think it was trying to block your exit?
No, ma'am.
Do you recall telling Detective Quinn that you were thinking that it was the folks, that it was DK's people who were blocking your exit?
No, ma'am.
Do you recall telling Detective Quinn that you thought maybe it could have been the people that DK was robbing or who were with the people DK was robbing that were blocking your exit?
Okay, this just in. Supreme Court, SCOTUS, has ruled that former President Trump cannot be excluded from the ballots in Colorado. And I assume this applies to all states. I have no idea, but yeah, that this news broke half an hour ago. So now you know too.
No, ma'am.
Do you recall telling Detective Quinn that you believed it was possible that the victims of DK's robbery were trying to retaliate against him and you all?
I don't recall.
Do you recall telling Detective Quinn that you don't know what anyone else saw, but you didn't see the officers in full uniform?
I don't recall.
Do you recall telling Detective Quinn during a September 2013 interview, I didn't see them. I'm driving, so I can't tell you about an officer in uniform?
No, ma'am.
And according to Robert Barnes, the decision from SCOTUS was unanimous. So it's not 6-3 as in supposed conservatives and non-conservatives. It's unanimous. The Colorado cannot keep Mr. Or former President Trump from the ballot. And again, I assume that goes for all states.
Do you recall telling the
Which will be interest. I have no idea what's in the decision or how it applies to the Georgia RICO. I don't know. I assume I will get news about this during this stream.
Detective Quinn, you didn't think it was the police because you didn't think 12 would be backed up in a Taurus?
No, ma'am.
Do you recall Detective Quinn telling you you knew it was the police because you called them 12 during an interview or a call from the jail with your wife? Do you recall Detective Quinn telling you that in a September 2013 interview?
I don't recall, ma'am.
Do you recall Detective Quinn saying to you that you, Mr. Bean, said that 12 started shooting into the car while you were talking with your wife and another dude while you were in Rice Street Jail? Do you remember Detective Quinn telling you about hearing that call?
No, ma'am.
Do you remember Detective Quinn confronting you with a statement you made to your wife and another gentleman that 12 were shooting, police shooting, and that DK was shooting at 12?
No, ma'am.
Do you remember Detective Quinn telling you that he was going to put that up as evidence?
No, ma'am.
Do you remember telling Detective Quinn during a September 2013 interview that you had gotten hit by a police car?
No, ma'am.
Do you recall telling Detective Quinn during a September 2013 interview that you knew it was 12 after you had gotten run over because that same car ran you over, and that's how you knew it was the police?
I don't recall, ma'am.
Yep.
Do you recall telling Detective Quinn that the female in the police car ran you over? When you saw them in the car, you were then like, damn, this is the police. The police just ran me over the top. Do you recall telling Detective Quinn that?
I don't recall, ma'am.
Do you recall telling Detective Quinn that you would have stopped for the police?
I don't recall.
Do you recall talking to Detective Quinn about another hearing you had the following week after your interview with Detective Quinn?
No, ma'am.
Do you recall Detective Quinn telling you he did not want to talk to you about any other case that you may have?
No, ma'am.
Do you recall asking Detective Quinn whether or not you were charged with anything?
No, ma'am.
Do you recall on September 16th or 17th of 2013, Detective Quinn telling you in an interview at the Atlanta Police Headquarters that you had not been charged with anything yet? He was still working that out.
No, ma'am.
Do you recall Detective Quinn telling you that he was going to sit down and look through what you all did and come up with his decision?
I don't recall.
Do you recall telling Detective Quinn, that's why I said, I don't want no robbery, man. I'm one of the guys who was in the car. Whatever went on that day, you know what I mean? I don't want to be an accessory to whatever they did. So it is what it is, man. I just like to know and not to know, you know what I mean? Do you recall saying those words or something similar to Detective Quinn during a September 2013 interview?
No, ma'am, I don't recall.
Do you recall Detective Quinn asking you, why do you all talk like that on jail calls? You know we listening.
I don't recall.
More breaking. Regarding District Attorney Fannie Willis. The Georgia Senate Committee looking into the Fulton DA has subpoenaed Attorney Ashley Merchant to testify Wednesday, which is this Wednesday. The hearing will be live streamed and open to the public. Okay, I need to reschedule a lot of things this week. Okay, so we have a SCOTUS decision. We have news on the Fannie Willis. Today is the last day before a 1-week pause on the Young Thug trial. And today haven't started yet. And today is a half day. So, yeah, this will be interesting. Now, depending on how everything goes, John Comyn, I presume the Trump RICO case will not end up having an effect should it be brought up to the Supreme Court. I just downloaded the Supreme Court decision. I assume Mr. Trump's lawyers will file a motion as soon as they get Judge McAfee's decision on the disqualification. There's a lot of things going on, and the day 41 still haven't started. So let's keep listening to this. Hold on a second.
Do you recall Detective Quinn asking you about the man you were talking to on the phone while you were at Rice Street the night you got arrested, that your wife called for you?
No, ma'am.
Do you recall Detective Quinn asking you about telling that man the story about what happened on September 11, 2013?
I don't recall, ma'am.
Do you recall telling Detective Quinn that that was your brother-in-law, Frederick Lee?
No, ma'am.
Do you recall telling Detective Quinn that that person was your wife's sister's old man?
No, ma'am.
Do you recall Detective Quinn telling you that he wanted to get you back to Rice Street before shift change?
No, ma'am.
Do you recall Detective Quinn telling you that you all have got to stop going on these missions?
I don't recall, ma'am.
Do you recall telling Detective Quinn in a September 2013 interview, I got my own will, I got my own car, my own house, my own family, my own money? Do you recall telling Detective Quinn that?
No, ma'am.
Do you recall telling Detective Quinn, I just know those guys and what they're up to? They're younger than we are.
No, ma'am.
Do you recall telling Detective Quinn, It ain't shit for them to do something and get away with it.
No, ma'am.
Do you recall telling Detective Quinn that those guys would even try you?
No, ma'am.
Do you recall reiterating to Detective Quinn that you hustle for a living? And all this shit was now coming on to you. Do you recall telling him that in September 2013?
I don't recall, ma'am.
Do you recall telling Detective Quinn that you had already prayed and made your notions to get your stuff together when all this stuff came up?
No, ma'am.
Do you recall telling Detective Quinn in a September 2013 interview that you and Big Dirty Red were family?
No, ma'am.
Do you recall telling Detective Quinn more than once that Dirty Red was like your family?
No, ma'am.
Do you recall Detective Quinn asking you, if DK is from that neighborhood, why would he take the chance on robbing without a mask on?
I don't recall.
Do you recall telling Detective Quinn that that's how they rock, man? They're young.
I don't recall, ma'am.
Do you recall Detective Quinn allowing you to use the phone?
Okay, day 41 have finally started. So I'm going to skip ahead because there was half an hour more. Then they had a pause, brought back.
You were charged in indictment.
And here is the final. This is the report. She has been asking questions through this entire time. And now she's entering it into evidence. Now, after days of direct examination, now she gets it into evidence.
I'm
So,
approaching you with states 157 Charlie. Is that your name on this document, the front page of it?
Yes, ma'am.
And I'm going to now turn to the middle of the document, ask you, is that your signature?
Yes, ma'am.
And is the name under your signature the name of someone who has represented you and in fact came with you at one point this year?
Yes, ma'am.
Now, looking at states 157 Charlie, and specifically page 5 through 10 of 157 Charlie. Because looking at states 157 Charlie, refresh your memory as to whether or not you were convicted and charged with any offenses that related to September 11th, 2013, the incident involving the shooting with the police officer.
this could have been the only evidence.
No, I still don't recall, ma'am.
You still don't recall? Could you say it a little bit louder so everyone can hear?
Still not recalling, ma'am.
This could have been the entire evidence.
Thank you, Mr. Bean. Your Honor, at this time, the state tenders the self-authenticating document labeled State's Exhibit 157 Charlie, which is the certified conviction for Mr. Adrian Bean. And
I can't count that high, John.
122087 in Fulton County Superior Court.
Any objection? Okay, it's admitted.
Self-authenticating, as in he actually signed those documents. He was convicted and charged and convicted. So they are self-authenticating, even though he claims he doesn't remember it.
Thank you, Your Honor. And Judge, at this time, I have no more questions for Mr. Bean.
Okay. Councils, you all want to just defer until tomorrow, I should say till Monday, since we have about 10 minutes left.
10 minutes, you can start cross-examination. I think Judge made a bad call here. Because he knows the tactics. To have everything in for the prosecution and then let the jury think about it over the weekend. I think he did a bad ruling here to make them wait until Monday, as in today. But he still did. So, yeah, that was day 40, the recap. Now we are going live on day 41. Dun dun dun, dun dun dun, da 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 da, dun dun dun. I don't know why Mr. Williams has decided to have his dreads out. Not my problem.
All right, Mr. Huey and Mr. Matthews Jr. and Senior, good morning. All right, Mr. Nichols and Mr. Lamar, actually, Mr. Garner should say good morning. All right, Mr. Ryan and Mr. Williams, good morning. All right.
So, first of all, half an hour late. Second of all, it's a short day. And still he asked the jurors, instead of telling them, this is 2 hours tops, and then it's lunch or something. I mean, it's, why not just have them the entire week off? Because he's still wasting everybody's time, this judge. Everyone's time.
Ms. Hilton, Mr. Atkins, Ms. Love, and Mr. Courtroom. You're already in.
Good morning to you, sir. Your Honor.
Oh, don't be trying to get over that, man. You're already in hot water. So who do I have the pleasure of now being with you?
Your Honor, sitting next to Mr. Ryan and Ms. Renard is Haley Haltwanger, Haltwanger. She is a second-year law student at Georgia State University. I've had the honor of working with,
Hello.
Ms. Haltwanger approximately 2 years. She's a fabulous lawyer representing the next generation of lawyers, and with the court's permission, we'd like her to sit at the table. Mr. Adams, who is no disrespect to the court or Mr. Williams or anyone, he is not going to be here today. He is actually in another court the week on a trial. So can never replace Mr. Adams. I'm not trying to do that, but with the court's permission, that's who is in your honor.
Okay, Mr. Williams, you okay with that? Okay, all right. Okay. All right. Mr. Bean outside?
He is, Your Honor. Before we get started, I'd just like to ask if the court would allow us an opportunity to look at some certifieds that Mr. Steele indicated he has. He indicated he would show us the certified on this, and the court came in right before he had an opportunity. So before we bring Mr. Bean, we just see a copy of the see the certified itself.
Sure. You all can look at those.
The certifications, I assume, is the Mr. Dean's retraction of everything he said. But I don't know, can't be sure. This is actually live. We are just a few minutes behind. Yay!
Limited that the court also has some indictments that he intends to use, and I moved in limine that the court preclude Mr. Steele.
Oh, hold on here.
Been able to look at a copy.
What
Thank you, Your Honor.
indictment?
We have been able to look at.
Yeah, here's the thing. If they have some, I mean, this prosecution has been throwing new stuff on the defense all the time. And now they are whining because the defense have some certifications.
A copy of the actual certified copy, NSC 130460, and based on information that Mr. Steele shared with me just now, I don't want to speak prematurely, but it appears that he also has some indictments that he intends to use, and I moved in limine that the court preclude Mr. Steele from any attempts at impeachment or improperly introducing indictments that are not certified convictions of this witness or any other. Based on the information that he just gave me when I asked to see the certified copies of conviction, he has only given me one certified conviction for Adrian Bean, and that is for Fulton County Indictment 14 SC 130460.
Okay, so there's no argument about the certified, is that right?
Correct, there's
Okay,
no
all right.
argument about this.
And then what about the uncertified or the, or do we? Is that what you're asking me to,
Yes,
or to pose or weigh in on?
yes, because I've just been told that Mr. Steele has copies of indictments. I don't know.
You have certified copies of those convictions, sir?
If you have social media, don't hesitate to share the link to this stream so we can get a few more people in here. I would very much appreciate that. Oh, and remember, thumbs up, always a good thing, makes YouTube's promote me to a larger audience. The more thumbs up, the more chance of me being promoted to more people. Thank you.
And good morning again. As I told the district attorney's office, they're certified copies of charges of an indictment, not convictions. I told the district attorney I was not planning on seeking to admit them now, but they may become ripe. What happened in two different cases, if you want to know, is Mr. Bean was charged, serious crimes, armed robbery, I may be a little off here, but armed robbery, trafficking, marijuana, something to that effect. And the cases were dead docketed. Under Ridley, which is RIDLEY versus state, it's 368 Georgia Appeal 481. Your Honor, that's 890 Southeast 2D 385, 2023 case.
Question.
Okay, they are looking into these charges. I mean, if it's charges and convictions, it's in it's public records regarding this witness. So are they going to attack his credibility? I assume that's where they're headed, because they wouldn't do this if they had no questions to him. So I assume they're going for credibility here. His credibility regarding what he said to these officers back in 2013. So this, they could result in a hearing regarding these things. And the poor jury went there for nothing. And hello over at Rumble. I very much appreciate you hanging in there. Also on Rumble, thumbs up. Follow me on Rumble. You on YouTube, if you prefer Rumble as a platform, link is pinned on the top of the chat. Thank you.
Can I see 157C, if you don't mind? Should be certified. May I approach the,
You may, sir.
Okay. I still feel very sorry for the jurors who came in today at 10:30 and are still waiting. Still waiting.
Still was, I don't want to incorporate this morning, but that's all right. Go ahead, sir.
I have a hard copy. I only have one though.
That'd be great. Thank you.
I apologize. I only have one
All right.
hard copy. So. 481. May I approach your Honor?
You may, sir. Thank you.
May I, Your Honor?
You may.
Okay, so what the court in Ridley explains is that the confrontation clause in the 8th paragraph, Your Honor, it's on page 2, and I've explained that to Mr. Brown of the state. The confrontation clause of the 6th Amendment guarantees to the accused the right to inquire about a witness's pending criminal charges in an effort to show that the witness has a possible bias, prejudice, or ulterior motive that may influence the witness's testimony. Whether the witness is testifying pursuant to a deal with the state is not crucial to the right to conduct such a cross-examination. And then, Your Honor, on the two items that I may not use, but that the state was inquiring about, and I just put them on notice of it, again, with Thug Drive today, and I told them, is Seals, S-E-A-L-S versus state, 311, Georgia, 739. And it's in Division 3B, as in Barry Bravo, and specifically, Your Honor, if I may have one copy, may I approach? Yes.
Yeah, I agree. If the jury is late, this judge is, don't do that again. If the defense, according to this judge, is wasting time, the judge has been on time one day. Or when I say on time, less than 15 minutes late, one time in 41 court days. Once has it been less than 15 minutes late. It's not, the American justice system relies on the credibility of the prosecution and the judges. And if this is how they handle that responsibility, then oh no.
A case is that Seals, that actually determined it. That's our case in Georgia that made this, that a dead docket case remains pending. So because the cases are dead docket, not null pros, they actually are pending with Mr. Bean, could be brought back on the live docket with the court's permission. The reason I said I gave it to the state, I just gave them everything. The reason I did that was in abundance of caution, that it came up and I felt needed to do it. So I want to be courteous, as you told me to do, and you told everyone to do. So that's why I did it.
Sorry, I have from another source here that they believe this evidence Mr. Steele is trying to get in is an interview he had with Mr. Bean 2023 in just to impeach the testimony under direct examination, which means I don't recall, ma'am. I don't recall. No, ma'am, I don't recall. And it's a 10-minute video. And in there, supposedly, Mr. Bean claims whatever he said to Detective Quinn and the others, that was a fabrication because he was trying to get out of trouble. And thinking about it, I mean, he got charged and convicted. So apparently, the cops didn't believe him back then when he said, oh, Mr. Williams was there and this was there and the shots came from there. Apparently, they didn't believe him. But this prosecution now wants the jury to believe what he said back in 2013 was correct, even though nothing supports it. The only thing that puts anybody near that car, the flying car thingy, is his testimony. And if the defense can show this man is not credible, yeah.
But as I told the state, I'm not really planning at this point to use them. They are older, Your Honor. I wouldn't be using them for impeachment. I think I'd be barred by the 10-year rule unless you made a finding that it was critical. But I can impeach with Mr. Bean with other convictions, so I can't really argue that it's, quote, critical to impeachment of this witness. I'm not saying the witness is not critical, but, you know, I have other manners and means to impeach him, I believe.
But he might open the door as to other things.
Exactly. And that's why I just did it at a bunch of custom, but I'm not really there in my mind. But I just wanted to advise the state. I also gave them about 6 this morning. I gave them about a 10-minute interview that, you know, Honorable Investigator Jimmy Martin Jr., which is, it's really James, J-M-E-S, Martin Jr., and I did with Mr. Bean. It was Sunday, January 22 of 2023. And I will be using that for impeachment because, respectfully, I know it's a jury question, but I believe he was not straightforward on his testimony on direct last week. And It's also a prior inconsistent statement, but it also goes to trial testimony under oath, which can be impeached at all times. So I gave that to the state early this morning. It's only a 10-minute.
Your Honor, two things I want to point out. Mr. Steele has had apparently this interview since January 22nd of 2023, if I heard him correctly. He did just send it to us this morning at 6 o'clock. That part is okay. The part that is not is that he would have to confront and lay a foundation for the playing of any audio recording that is out of court. Any such recording is barred as hearsay under 24A801 unless there is a, unless he can establish, unless he can confront, unless he can somehow establish that there is an exception to the hearsay rule for that particular statement. Secondly, the indictments that he has given us copies of, I believe for no reason should be allowed because they are way more than 10 years old. They are from 2011. He has.
Ms. Love, the only reason why some of the charges are in there at all is because you argued that statute of limitations should not apply. Because one of the charges is murder. One of the underlying acts are murder. That means all underlying acts goes under that umbrella of no statute of limitations. Now you want to limit the defense. So you want to have the limitations gone, but the defense are not.
In addition to the certified for 14 SC.
I don't think that's the issue. He's just bringing them to the attention of you and the court so that if your witness should open the door as to him, I would make some certain probably findings at that point in time.
Yes, Your Honor, I understand. I, of course, do not intend to inquire into the defense's strategy, but for the sake of arguing that somehow there is a reason that this witness would want to cooperate with the state, that is what Ridley is intended to stand for. They would be able to show through open cases a witness's reason for wanting to cooperate with the state. And again, I would argue that these three, 11 SC, 06 SC, and 13 SC cases for which Mr. Steele provided us indictments this morning are not permissible under any of those circumstances. And I, before he even tenders or walks to the witness to attempt to show them or even mentions them in front of the jury, I would ask that the court require Mr. Steele to, at the very least, outside the presence of the jury, tell the court what he intends to use them for. Because otherwise, once the toothpaste is out of the tube with respect to some impermissible document or impermissible item he wishes the jury to know about, it's already out. So I would ask that the court preclude him from even mentioning, tendering, or asking the witness about any 11 SC case, 06 SC case, or 13 SC case that he has given us a copy of an indictment of for any reason until he, outside the presence of the jury, tells the court for what reason he intends to try and introduce it. Because again, we would argue that it's impermissible. It would be, as he stated himself, it's not permissible impeachment evidence. It is over, they are all over 10 years old. They're all closed cases.
But well, they're dead docketed, right?
Okay, that's not.
They're dead docketed. These two cases are apparently on the dead docket, right?
So the 11 SC case and the 06 SC case are either, no, they're dismissed for all intents and purposes. But the point is, and the 13 SC case, let me make clear, I believe that one is actually states 157C. I believe he was sentenced for that one. So as far as if this is the same one that we've already introduced, we have no objection to that being used. But the 11 SC case and the 06 SC case were dismissed against Mr. Bean well over 10 years ago. And
Okay, all right. Were they dismissed? How were they dismissed? Were they placed on the dead docket? Were they null pros?
we don't have
Were
a
there
certified
verdict?
copy of the file. So all that we have is a copy of an indictment with nothing more from the file from Mr. Steele.
So how do we know? How do we know how it was resolved?
Because the copy of we don't know exactly how it was resolved beyond what Mr. Steele has shown us, which is the indictment itself with the word as to Adrian Bean. The counts are, the counts are placed on the dead.
You have, yeah, whatever.
Docket in July 2011.
Okay, well, if they're
And I
placed on
don't
the,
know.
oh, stop. If they're placed on the dead docket, that case still is technically open. It can be prosecuted, and that's what the case law seems to
The
indicate.
statute of limitations has run on these items, and we cannot. We've dead docketed it in 2011. We can't bring it back.
You know, the statute of limitations is satisfied once the indictment is returned in open court by the grand jury. There's not a statute of limitations issue with a dead docketed count.
Again, Your Honor, since Mr. Steele has indicated that this issue is not right, my only request of the court is that before
well-
Mr. Steele mentions it, he, at least outside the presence of the jury, tells the court for what purpose he intends to
Let me
try.
ask, let me ask you a question. Mr. Steele, do you have some basis to believe that the state has offered Mr. Bean a deal or has indicated they're not going to take these these dismissed cases off of the dead docket? Or what's your theory of how you might confront the witness?
He would, no, to answer your question directly, no, I don't have any reason. We faith believe that the state is saying it's coming off the dead docket, but under Ridley, R-D-L-E-Y, that's not the issue. That's exactly why I gave you the case. It goes to the state of mind of the witness who is testifying, and the jury makes that determination.
The state of mind as to how?
Because what
Really doesn't say that.
Yes, it does. If you-
Where in really does it say that? Point to the
started-
page. I want to see it.
Started the 8th paragraph, which I think is on the 2nd page, Your Honor, and then go to the 3rd page. And it says in the very top left-hand, I'm going by my memory, but top left-hand corner, it should say whether the witness is testifying pursuant to a deal with the state is not crucial. I'm going by my memory.
Yeah, that's
right.
pretty close. Okay.
To the right to conduct such a cross-examination. So it's a pending charge. This isn't about a deal. This isn't about conviction of 10 years of age. I just, I went straight with the court. I'm just telling you, I understand that if it was a conviction, I wouldn't be able to use, I have other convictions for him, but they're over 10 years of age. I'm not trying to get those in because I don't think it's right to ask this honorable court to make a balancing test.
So you're saying he's still facing charges, and that's what you want to ask him about?
Yeah, that's all that issue is.
All right.
It has nothing to do with the statute of limitations. It has nothing to do with a conviction. I'm just doing what I think lawyers should.
That's clever. If Mr. Bean believes he can still be prosecuted, has nothing to do with his knowledge about the statute of limitations or the actual statute of limitations. Oh, that's smart, Mr. Steele. This is why Mr. Steele is paid the big bucks. Oh, that's clever, Mr. Steele.
Yeah, just being straightforward.
Your Honor, under 403, given that these are dead docket charges in 2011, and I don't believe that Mr. Steele or Mr. Williams has any good faith basis to argue that under Ridley, he should be allowed to introduce this 11 SC case in this 06.
That's what really seems to indicate, and it tells me under 403, it's an extraordinary remedy which should only be used sparingly. So if he wants to ask him about he's facing charges, he's technically still facing charges, and he would be permitted to do that if it comes up. Okay, so but right now I would let him do that.
Well, with that being said, then I would do
Oh,
Your Honor,
Okay.
good ruling, Your Honor. Stop whining, prosecution. He
He's
made
still
his
facing
ruling.
charges. He's got a dead docket. Dead docket stops the statute of limitations. It's still open case. How many employment times have witnesses or other people faced dead dockets? And
Oh, something is coming back to bite the prosecution in the butt. Because if they keep stuff on the dead docket, they do that because sometime in the future, maybe via RICO case, they can reopen because it puts a stop on the statute of limitations. So some prosecution, when you do this, it might come back to bite you in the bum. I'm not past 2 hours, so I will try to refrain myself from 2-hour words.
And because the same thing, because it's still an open case. That's my ruling. Can we move on?
yes, Your Honor.
Okay, all right. If it comes down to it, so yeah, he's got a good faith basis. So if it comes down to it, he can ask those questions. All right, anything else?
not on behalf of Mr. Williams.
Okay, all right. Sorry, name, can you summon our jurors for us, please?
And Your Honor,
No.
Mr. Steele will not be attempting to play any hearsay. He won't be tendering any, to my understanding, without laying any foundation for that.
All right, ladies and gentlemen, please be seated. All right, thank you, Sergeant Ingram. All right, ladies and gentlemen, good morning. All right, you sound good. Okay, all right. Ms. Love, I believe that we still had Mr. Bean with us, so can we summon him, please?
Yes, Your Honor.
All right. Mr. Bean, good morning. Come on up again.
Yeah, this was a huge win for the.
All right, sir, you're still under oath, okay?
Yes, sir.
All right, thank you, sir. All right, cross, Mr. Steele.
Don, I was so hoping he would wear a T-shirt saying "No, ma'am" on it. I was so hoping for it. But why does he have a Rebel Minds vest on him? I mean, it's not very bad, but not the right message you want to get to the jury, maybe. Oh, well.
Thank you, Your Honor. You were released from prison in approximately 2017. Is that correct?
Yes, sir.
And since you've been released from prison, you have been gainfully employed. You've been working, right?
Yes, sir.
And you work for, I believe, currently, and if I'm wrong, just tell us, for the city of Atlanta, is that right?
No, sir.
Who do you work with currently?
I'd rather not say who I work for, sir.
Okay, what do you do currently for a living? How about that?
I'm a foreman.
And explain what type of foreperson.
Foreman.
You said a foreman.
A supervisor.
Okay, for what type of work?
Traffic control.
Okay, traffic control. I'm sorry, I'm having a hard time hearing. Traffic control?
The traffic control.
Okay.
So he's not working directly for the city of Atlanta, but for a subcontractor with a contract with the city of Atlanta? What? Ah! Oh. Oh.
And how long have you been doing that?
I really can't recall.
One more time.
I can't recall, sir.
Has it been more than 2 years?
Yes, yes, sir.
Okay. And are you working other jobs as well currently?
No, sir.
All right. With regard to your testimony last week, Thursday and Friday, you said a lot of, I don't recall 2013. Do you remember something like that?
Yes, sir.
And I think you explained or tried to state that that was a bad time in your life. You blocked it out. If I'm misstating that, just correct me.
I don't recall anything from 2013, sir.
And why is that?
I just don't recall. I remember. I just don't recall, sir.
Do you remember things in 2014?
No, sir.
No? Yes or no?
No, sir.
2015.
I don't recall, sir.
How about 2016?
No, sir.
2017?
I just remember what I need to remember in 2017.
That's after prison? Is that what you're saying?
I mean, I was released from prison in 2017.
And is your memory good after 2017 released from prison? Do you remember whenever month, I don't know the month, you were released from prison, you remember that? Is that what you're telling the jury?
Yes, sir.
And you remember then 2018?
Your Honor, I object that's vague. That's a broad question and not specific
Okay,
enough.
I'll stand the question. Just rephrase, Mr. Steele.
Do you have a memory of things you did in 2018?
Again, objection vague.
I'll let him answer the question. I'm over the question. You can answer, sir.
2018. What I'm remembering in 2018.
You don't?
What am I remembering in 2018, sir?
Anything, where you were working, how about that?
No, I remember where I worked in 2018, sir.
Okay. Do you remember being home in 2018, not incarcerated?
Yes, sir.
All right, how about 2019? Same question.
What am I remembering?
Same question.
Every year you ask me, what am I remembering for every year that you ask me about this certain type of year? That's what I'm trying to get you to understand.
Answer my question. Do you remember where you were working in 2019?
No, sir.
Were you working in 2019?
I don't remember.
Were you living free in 2019?
I'm free.
Were you living with your wife in 2019?
I've been with my wife in 2019.
Same question. 2020. You remember that year where you were working?
I've been doing the same job for quite some years now, so it'll run into all that. It's 24 now. I've been working by 7, 8 years now. The working part's gonna be what you asking me about, sir.
And you remember that in 2020, right? Yes or no?
Yeah.
And 21, same question.
Okay.
Remember
Yeah.
that?
This might be a lot spicier than I anticipated. Mr. Steele has some crap he wants out of him. Of that, I'm sure.
I'm in my work 21. I'm in my work 22. I'm in my work 23. I'm in my work 24. This year right now, what we're looking at.
How clearly do you remember 23 and 24 years? This year and last year?
Not too good.
I can't hear you.
Not too good.
Mr. Bean. Do you remember being convicted of what has been marked as State's Exhibit number 157C, as in Colette or Charlie, that you identified last week? Do you remember that?
No, sir. I don't know.
Your Honor, with the court's permission, may I show electronically 157C in Colette? And Mr. Kokomo, if you can help me out. It's already in evidence, Your Honor.
Yes, sir.
Oh, he's
It should be on the screen. You can look behind you or right next to you in a moment.
Oh.
I want to go through this with you. Okay, Mr. Bean, what's on the screen is been already admitted on March 1, 2024. This is the Superior Court of Fulton County, State of Georgia versus you. You see that on the left-hand side of that first page?
Yes, sir.
And you see where it says filed in the office of the Deputy Clerk of Superior Court, Fulton County, and gives the date of October 15, 2015?
It's gonna still be the same.
I can't hear you.
It's gonna still be the same. I seen this paper last week. The same paper Mr. Love showed me last week.
I just cannot hear you.
Friday. It's gonna be the same thing. I seen this paper before.
Answer my question. Do you see it says October 15, 2015, filed in the office of Deputy Clerk, Superior Court, Fulton County?
Yes, sir.
And you see in the next column to the right, there's a rectangle and it has your date of birth, June 22, 1979. True?
True.
Okay. And then if you go down on that page with Mr. Kokomo's permission, you see it lists certain charges on the left-hand corner. You see that? Left-hand side? It goes from 1, 2, 3, 4, 5, 6, and then it skips to 9. You see that?
I see it.
Okay. And then it says in the disposition, you see 2 columns over, after it says charge, and then you see disposition.
Yes, sir.
And on count 1, it says guilty Alford. Right?
I don't know.
Do you see it?
I don't know.
It's an Alford plea. If it is, as I remember, that is when you plead guilty but not admitting to the charges because the evidence is too overwhelming. So you plead guilty to it without trial, but under the Alford rule. Oh. That's interesting. That's really interesting.
I can't hear you.
I don't know.
Do you see it? Is
I
what I'm
can't
asking.
really see it.
Yes?
Okay. Where you think it? Yes, sir.
Okay. And then it says for the sentence, 10 years to serve 3 years. That's in prison, right?
Okay.
Balance probated 7 years, right?
Okay.
And then it says concurrent with, and it gives another indictment number. You see that?
Okay.
And that's indictment number 14 SC 130460, which we're going to discuss in a moment. All right? Okay? Yes? All right. Now, this is October 15, 2015, and the total sentence here is 10 years, right?
I don't recall it.
Well, that was your sentence.
I don't recall this, sir.
Okay. This is the same document you recalled last week on the 1st of March, right?
But I still didn't recall it.
All right. Count 2, you see on the left-hand side, count 2, it says aggravated assault against a police officer, vehicle on vehicle. You see that? You see that?
Yeah, I don't recall none of this paperwork right here, but you're showing me on this.
All right, well, it's in evidence, so we're going to go through it. Again, you put guilty under Alford, right? And the same sentence, 10 years, is total sentence, 3 years in prison, with balance of 7 years on probation to run concurrent with count 1. Okay? That's what it says, right? Yes or no?
Sir, you got to answer the questions, okay?
Yeah, I guess it's on the screen. Yes, sir.
Count 3 is again aggravated assault against a peace officer, and again guilty under Alford, 10 years to serve 3 years, balance 7 years on probation, concurrent with count 1, right?
I never pleaded to this.
All right, we're going to talk about it. We'll go through the whole document.
I thought you didn't remember, Mr. Bean. I thought you said you didn't remember anything, but here, all of a sudden, I didn't plead to that. I thought you didn't remember. Whoopsie daisy.
The next one is count 4, 5, and 6, and that's armed robbery, aggravated assault with a deadly weapon, and possession of a firearm during the commission of a felony, and all those were no pros, were dismissed. You see that?
Yes, sir.
All right, and then the last one is count 9, fleeing or attempting to elude, misdemeanor, and again, guilty under Alford, 12 months to serve, concurrent, run at the same time as count 1. That's what it says, right?
That's what it said.
All right, let's go to page 2 with Mr. Kokomo's permission. And these are the terms of the sentence summary. You see that right there where Mr. Kokomo stopped? You see in bold, it says sentence summary.
Seen the song, yeah.
Okay, and defendant is a word used for somebody charged with a crime, right? You know that?
I didn't know that.
Like a plaintiff is a state or a defendant is a person charged in a civil case. Do you know what I'm talking about?
No, sir.
No? Okay. Well, it says the defendant is a judge guilty.
Yeah, I just had to turn monetization off because I got a warning from YouTube. Jesus Christ, YouTube, I'm covering trials. That's what I do. Nobody is here by accident. Not one is here by pure accident. They know it's a trial, all of you over at YouTube. They know it is.
Excuse me, I'm in the wrong place. The defendant is sentenced for a total of 10 years, with the first 3 years to be served in confinement, the remainder to be served on probation, right? Then it says, or, and if it's not checked, to be served on probation. So you were sent to prison, right?
Matt asked, is there any real difference between saying I did not plead to that and I don't remember? Yeah, it is. Because if he says verbatim, I did not plead to that, that means he has a recollection of how he pled, in my opinion.
You see that?
You say so.
That's the prison you're talking about with the jurors that you said you got out in about 2017, right?
Yes, sir.
All right. And then if you go down to the next line, the defendant, which is just the way it's termed, but you are to receive credit for time served in custody as determined by the custodian. That's the Department of Corrections for the state of Georgia, right? You see that?
Yeah.
And then on the next one, which is box 2, it's checked. Upon the service of 3 years, the remainder of the sentence may be served on probation, provided that defendant shall comply with the conditions imposed by the court as part of the sentence. And then it goes through general conditions of probation and special conditions.
Ladies and gentlemen, I think he's still under probation. If he got out in 2017 with 7-year probation, he's still on probation. Okay.
Conditions underneath. Okay? You see that?
Mm-hmm.
All right. And then Mr. Kokomo can scroll down and it's checked, or X number 2. Probation supervision fee is waived for the first 6 months after release. You see that?
Yeah.
And then on the next page, it says special conditions of probation. And you waive your 4th and 5th Amendment rights, meaning you have to answer questions. Right? You know what the 5th Amendment is?
Your Honor, I object as to the commentary about having to answer
I
questions.
sustain the objection.
Do you know what the 5th Amendment is?
Your Honor,
I sustain the objection.
To the 5th Amendment? Ask him if he knows what it means. Okay. You waived your 4th Amendment and 5th Amendment rights. You see that?
I'm looking at it.
Okay. And then maintain employment, undergo regular random drug screens, obtain a GED, and then back to that court if your probation is going to be revoked. You see all that?
I'm looking at it.
And revoked probation means you go back to prison instead of being out on the street under supervision of a probation officer, right?
I guess so.
You don't want to go back to prison, do you?
I mean, what do you mean?
I'm
What do
asking
you mean? So do I want to go back to prison?
You don't want to go back to prison, do you? Do
If I had to go, I would. I went to prison.
you want to go back?
I've been to prison before.
Did you enjoy prison?
Your Honor, objection.
I sustain the objection.
I mean, I did mine. I did my time.
Underneath that, if Mr. Kokomo comes down, you hired a lawyer, go down a little more, named Ed Adams. You see that by employment?
Yes, sir.
Okay. And then that court was the Honorable Judge Downs, who sentenced you. You see that?
Yes, sir.
Now, Mr. Williams never paid for any of your lawyers, right?
No, sir.
He never made any bond for you, right?
No, sir.
The next page
That
of this
you
document,
remember.
157C, as in Colette, Charlie,
Was credibility.
keep going down, is the indictment. I want to go through the indictment with you. Okay. If you go up a little bit. Perfect. Thank you, Mr. Kokomo. Go down just one more to get count 9. Now, on this indictment, Mr. Bean, in State's Exhibit number 157C, as in Colette, Charlie, you see the indictment number there in the center, written in 13SC122087. You see that?
Yeah, that's what it says.
And it says State of Georgia versus, and the first person is you, with count 1, 2, 3, 4, 5, 6, and 9. Same counts that we just discussed on the sentencing page. You see that?
That's what it says.
And then
There
you have the
really
next
is
person
not
charged is
there.
Walter Murphy. You see that name?
Yeah, that's what it says.
And he's the same Walter Murphy that you discussed earlier. According to, you said you didn't recall, but he was referred to by the Honorable District Attorney as DK. You remember that?
No, sir.
All right. And he is also charged with you in count 1, 2, 3, 4, 5, 6. Mr. Murphy's charged in count 7, but also in count 9. You see that?
That's what the paper says.
And then the last person is Frederick Medina, which is Medina, Prothrow, Prothro. You see that?
Yeah, that's what it says, sir.
And Mr. Prothrow is also charged in similar counts as you, but count 8. So he's charged in 1, 2, 3, 4, 5, 6, 8, and 9. You see that?
I guess that's what it says.
And this indictment was filed, if you go down a little bit, Mr. Kokomo. Originally, October 1, 2023. You see that?
It says 13.
You see that? Couldn't hear you.
I said it says 13.
Okay. And then for Walter Murphy, you see where he pled guilty to count.
Objection, Your Honor, as to having this witness testify about someone else.
I sustain the objection.
The documents and evidence.
Doesn't mean it's your objection. I'm sustaining.
Let's just, before we leave this page, just go up a little bit, Mr. Kokomo. Show the jurors where Jeffrey Williams is charged, along with you, Mr. Prothrow, Mr. Murphy, in this indictment.
You show me.
Yeah, that goes to even the people around, the cops, every cop, the prosecution at the time did not believe all the charges were dismissed. He's not there, which means the prosecution alleges that the police officers might have believed Mr. Williams was involved. Apparently, no indictment, no charge, no conviction, no nothing. And still, here we are spending about this on robbery. Close to a week and a half of testimony from cops who barely remembers the back of their hand, this guy and other things, just because it is an underlying act in the RICO trial, under the RICO charge. And Mr. Williams isn't even there. This is the quality of the prosecution's case. Throw as much pasta on the wall as possible and hope anything sticks. That's the entirety of the prosecution's case.
Hey,
I cannot hear you.
you can see it clear as day. It's on the paper. You show me. He's not there.
He's not there. Now, October 1, 2013, the return of this case, that is after you spoke with Detective Quinn at the City of Atlanta Homicide Office on recording on September 17, 2013. You realize that?
No, sir.
All right, if you can scroll down, Mr. Kokomo. And Mr. Bean, this is the next page. And you see in the top, just talk about you. So I'm excluding the first column, Mr. Prothero, the second column, Mr. Murphy. We're going to third column to the right on the top. You see where you originally pled not guilty with your lawyer, Ed Levance Adams, and your signature. You see that?
Yes, sir.
And it says October 29, 2013. You see that?
Yes, sir.
And then if you go down and it's on an angle on the side, or actually it's on the center right, you see where it says Adrian Bean with your middle name? You see that in the center, kind of right?
That's what it said.
And you see there's a check mark. You pled guilty under Alford to the indicted offenses in count 1, 2, 3, and 9, like it says on the first page of 157C. You see that?
Yes, sir.
And that's October 1, 2015 now. So it's 2 years and 3 weeks after September 11, 2013 that you're resolving this case. You see that?
So they waited 2 years.
That's what the paper say.
One more time.
That's what the paper say.
Okay. And then the other counts, if you look kind of on an angle, as to Adrian Bean, count 4, 5, and 6 is no pros. No pros means dismissed, just like it was on page 1. You see that?
No, I don't see it.
Mr. Kokomo, can you just orient Mr. Bean? You see where that pointer is?
Okay, sideways. Huh?
And that's also October 13, 2015, right?
I can't really see it.
Yes?
I can't really see it. Yeah, I see it. Wow.
You see it? Yes?
I see, yeah.
All right. The next page of this document is the actual charges that you were facing along with Mr. Plethro and Mr. Murphy. And you see the names of the grand jurors in the center. It says the grand jury is selected, chosen, and sworn for the county of Fulton to wit, and they charge you. You see that?
You know the paper say.
And count 1 charges you, Mr. Murphy, Mr. Medina, with the offense of aggravated assault against a peace officer for that the accused, that's you, and the other 2, in the county of Fulton, state of Georgia, the 11th day of September 2013, did intentionally drive and steer a motor vehicle at, towards, and in the direction of E. Robertson L., a peace officer employed by Atlanta Police Department as a police officer who was at the time of the said assault engaged in the performance of his official duties as a peace officer, said motor vehicle being a means likely to cause serious bodily injury when used offensively against a person. You see that?
It's on paper.
Okay. And you were driving that 2004 Nissan Altima vehicle at the time that you almost killed Officer Robertson L., right?
I don't recall, sir.
You knew Officer Robertson L. before September 11, 2013, right?
I don't recall, sir.
And on this one count, you entered a plea under Alford, and we'll discuss what that means. 10 years to serve 3 years in prison, right?
Yeah, I don't recall it.
October 2015.
Yeah, I don't really remember anything.
All right, let's go to count 2. This charges, again, the grand jurors charge you, Mr. Murphy, Mr. Plethro, with the offense of aggravated assault against a peace officer. It gives a code section. You know what OCGA stands for?
This is the difference between the prosecution and Mr. Steele. And this is probably why the prosecution didn't actually want to show this and only ask questions about it and then entered into evidence in hope the jury wouldn't look at it. And now, Mr. Steele, oh no, look at it. Mr. Williams is not mentioned in any of these documents. Yeah, no, Tony, I didn't see that until afterwards. I thought everything was done in my stream from the Fannie Willis closing arguments. That was crazy. DA Fannie Willis just stood up and stormed out as she stormed in and demanded to testify. I think she knows she's screwed. She should be screwed from the DAs from prosecuting the Trump case, because, and I don't even care about any sort of evidence against former President Trump. I care about due process, and Fannie Willis and Nathan Wade are two crooked people.
No, sir.
You do?
No, sir.
Okay. For said accused, that's you, Mr. Plethora, Mr. Murphy, in the county of Fulton, state of Georgia, on the 11th day of September 2013, same day, did intentionally drive and steer a motor vehicle into and against the motor vehicle, which was then and there occupied by A.C. Booker Higgins, a peace officer employed by City of Atlanta Police as a police officer, who was at the time of said assault engaged in performance of his official duties as such peace officer, said motor vehicle being a means likely to cause serious bodily injury when used offensively against the person. You see that count?
And that's what the paper said.
And you pled guilty.
Regarding Fannie Willis and Nathan Wade, I have acquired a depiction on how it might have looked at Aruba. Oh, I'm having so much fun. Too much fun with that. Let's go back to the trial. Sorry. Goes through the British definition of Fanny, makes your comment perfectly perfect. Yes, it does. Yes, it does.
Under Alford and were sentenced on that count, right?
No.
You didn't plead guilty
No.
to that count?
No.
Okay. Count 3. Grand jurors again charge you, Mr. Murphy, Mr. Plethora, with the offense of aggravated assault against a peace officer for said accused, County of Fulton, State of Georgia, on the 11th day of September 2013, did intentionally drive and steer a motor vehicle into and against the motor vehicle, which was then and there occupied by B. Porter, a peace officer employed by Atlanta Police Department as a police officer who was, at the time of said assault, engaging in performance of his official duties as such peace officer, and motor vehicle being a means likely to cause serious bodily injury when used offensively against the person. And you pled guilty to that and were sentenced, right?
I don't remember.
Okay. Then count 4 is going to be no process against you, but the charge is that you, Mr. Murphy, and Mr. Plethora were charged with the offense of armed robbery, for that you all, in County of Fulton, State of Georgia, the 11th day of September 2013, did unlawfully with the intent to commit a theft, take from the person and immediate presence of Derek Dotson, United States currency, the property of Derek Dotson by use of a handgun, an offensive weapon. That case for you was dismissed, right?
I don't remember.
Or no process.
I don't remember still.
All right. Mr. Kokomo, just go back to the very first page of State's Exhibit 157 for a second, please. And scroll down to count 4, 5, and 6. You see count 4, armed robbery we just read, and then it says in the third column, disposition, no process. You understand that? The same with count 5 and 6.
That's what the paper says.
Okay, let's go to count 5. What was dismissed against you? You were charged in count 5, along with Mr. Murphy and Mr. Plethora, with aggravated assault with a deadly weapon for said accused in County of Fulton, State of Georgia, on the 11th day of September 2013, did unlawfully commit an assault upon the person Derek Dotson by shooting at, towards, and in the immediate direction of Derek Dotson with a handgun, same being a deadly weapon. Your case was dismissed. That's what you were charged, right?
That's what the paper say.
And then count 6 is going to be the grand jury's charge you, Walter Murphy, and Mr. Plethora with the offense of possession of a firearm during the commission of a felony for that said accused, the 3 of you in the County of Fulton, State of Georgia, on the 11th day of September 2013, did unlawfully have on and within arm's reach of accused person a handgun during the commission of a felony against and involving the person of another, to wit, armed robbery. And that case against you was dismissed, right?
That's what the paper say.
Okay. And then number 7 charges just Mr. Walter Murphy with possession of firearm by a convicted felon. Count 8 charges Mr. Plethro, possession of firearm by a convicted felon. And then count 9 charges you, Mr. Murphy, and Mr. Plethro with the offense of fleeing or attempting to elude for that said accused, County of Fulton, State of Georgia, 11th day of September 2013, did willfully fail to bring his vehicle to a stop after being given a visual hand signal to do so by E. Roberson L., a police officer employed by Atlanta Police Department in uniform, prominently displaying his badge of office in an appropriately marked police vehicle. And you pled guilty under Alford to that, right?
I don't remember.
The next page has again your name, your date of birth, has 6/22/79, and then Mr. Murphy and Mr. Plethro's information. And then if you go down to the witness list, you see the witnesses, Derek Dotson, and then the police officers, including Detective Quinn. You see that?
Yeah, that's the paper say.
Okay. Now, that same day, you disposed of another case. You remember that?
No, sir.
Your Honor, may I approach?
You may, sir.
May I approach you? I'm showing you what I marked as dated today, Mr. Williams, number 199. You can look at the whole document, okay? I'm not trying to rush you. I mean, this is your signature.
No, sir. I didn't write that. I didn't write that.
Is that your signature?
I didn't write down one of them.
Is your lawyer, you recognize the signature of Ed Adams? That's your lawyer?
I don't know how his signature would be, sir.
Is that your lawyer?
Yeah, that was my lawyer, but I can explain to you about his signature.
And do you remember being charged and convicted of aggravated assault with a deadly weapon on September 7, 2012? Did commit an assault by shooting a person named Cameron Randolph? Do you remember that? I can't hear you.
No, sir.
You deny it.
I mean, if that was the paper say, I don't remember that. I don't remember the name back then.
Do you remember being charged in count 2 with aggravated assault with a deadly weapon on the same day, September 7, 2012?
Attacking his
by committing
credibility.
assault on James Butler by shooting James Butler?
No, sir.
You deny that.
Yes, sir.
You do realize you're on an oath.
Yes, sir.
Remember count 3, being charged and convicted of possession of a firearm by a convicted felon on the 7th day of September 2012, did knowingly and unlawfully.
I don't remember that, so still.
You had a firearm, to a handgun. You were a convicted felon from indictment number 01-SC-03-786. Superior Court, Fulton County, charged with possession of cocaine, intent to distribute on May 18, 2021. You deny that.
Sir, I don't remember that, sir.
And then on the last page, it has, again, your name, your identifying information, including 620.
This goes both to his credibility and the credibility of the state for bringing this up when knowing Mr. Williams was never charged, never indicted, never brought forward to a grand jury, and they still have this as an underlying act in this case.
279 is your date of birth, right?
That's what the paper say.
Your Honor, I have a certified copy of a conviction from the Honorable Fulton County Superior Court Clerk for State Georgia versus Mr. Adrian Bean, same lawyer, same date, judge down. I have a plea colloquy if you want it. And in fact, I have same date of birth on the document itself. I move it into evidence.
Have you shown that to the state? What
Of
are you
course.
marking there, sir?
Mr. Williams, number 199.
Any objection to Mr. Williams 199?
State has no objection to the self-authenticating document that is a certified conviction, that is William 199. I'm not certain what the rest of Mr. Steele's representation is regarding the colloquy, but the certified conviction the state has no objection.
I'll admit Jeffrey Williams 199. The actual certified copy of the conviction. The other allied documents can be separated. Okay.
Your Honor, may I approach Mr. Bean with Mr. Williams, number 199, that's in evidence, as well as states 157C in case he needs to refer to them.
Yes.
Can I approach you again?
Okay. What?
Can I?
Yes, sir.
I'm showing you, and I'm going to leave with you in case you need to see them. Just let us know if you're looking at them. This is Mr. Williams, number 199 in evidence. This is State's Exhibit number 157C. Okay. With Mr. Kokomo's permission, Your Honor, I would like to show on display Mr. Williams, number 199, that's now in evidence.
All right, there you show.
Okay, Mr. Bean, we are looking with Mr.
And this is good, actually showing this to the jury, which the prosecution avoided completely. This is good because it shows Mr. Williams was never indicted by a grand jury, never charged. This is good.
Mr. Kokomo's permission at Mr. Williams, number 199. It's on the screen. It's also right in front of you. If that's easier for you, you can look at either one. And at the top of that, on the left-hand side, again, it is State of Georgia versus you, Adrian Bean. You see that?
Excuse me. Can I say something?
Not really. Answer my question, and then you ask the honorable court.
Is that what the paper say?
What'd you say, sir? I'm sorry.
That's what the paper say?
And then this is for indictment number. You see under it, criminal action number 14 SC 1306. Excuse me, 0460. You see that?
Yeah, that's what the paper say.
Hello, Mr. Jingles. Mr. Jingles is here with his presence. Can you say hello to the audience, Mr. Jingles? Hello. Yes, Ghostery. Kitty's here. Kitty's here. And for you who haven't seen Mr. Jingles, this is Mr. Jingles. He runs the show. Nothing. I'm just here because he allows it. Hello, Mr. Jingles. What are you doing? Hello. Let's get back to the trial.
All right. And Mr. Bean, to the right of that, you see in that rectangle, it's the same date of birth for you, 6/22/79, right?
6/22/1979 has been stated to be my birthday. Yes.
Okay. And then underneath it, we are going to go to the charges. You entered a plea. It says a non-negotiated plea. You see that check mark right in the center top? Or it's not a check, it's an X.
That's what the paper say.
Okay. And then a little
I'll
down.
put a plea again.
You're charged now in 4 counts.
Seems
in
to
this
be a
indictment.
habit.
And the first one is aggravated assault with a deadly weapon, as well as is the second count. The third count is possession of a firearm by a convicted felon, and the fourth count is possession of a firearm during the commission of a felony. You see that in the second column on the left?
That's what the paper says, sir.
And then in the center, well, it's center left, you see the disposition. You again entered a guilty plea under Alford. So all 4 counts. You see that?
That's what the paper say.
And then next to it is your sentence. And you see the sentence now is 10 years to serve 3 years, balance of 7 years on probation. And that's to count 1 as well as count 2. You see that?
That's what the paper say, sir.
And then on the far right-hand corner, that says concurrent with the indictment number, which is in State's Exhibit number 157C, as in Colette, indictment number is 13 SC 12207. You see that?
That's what the paper say.
And then for count 3, and you get 5 years to serve 3 years, balance of 2 years probated. You see that?
Yeah, that's what the paper say, sir.
And that's concurrent with count 1 as well. Right?
That's what the paper say.
Okay. And then on the last count, it says 5 years to serve, suspended, consecutive to count 1. You see that?
Yeah, that's what the paper say.
And consecutive, means run after, right?
I don't know what the consecutive means, sir.
All right, well, the sentence summary, if Mr. Kokomo goes down. The summary is that you, the defendant, is sentenced for a total of 15 years. The first 3 years to be served in confinement, the remainder to be served And then if you go to the next page, the very top, you are to receive credit for time served in custody as determined by the custodian. And then number 2 is checked. Upon the service of 3 years in prison, or upon the service of 3 years, the remainder of the sentence may be served on probation, provided the defendant shall comply with conditions of probation. And when you go down, Mr. Kokomo, they're going to be the same conditions that we discussed earlier for your other conviction in State's Exhibit 157C. You see that?
Yeah, that's what the paper said.
All right. And then if you go down to the date, keep going down, please. And there again, you're represented by your lawyer, Ed.
For anybody who ever thinks about going into their Zoom and say stupid things, you're not helping Mr. Williams. Okay? You're not helping. Stop doing that. Let the lawyers do their job. Hello, Mr. Oh, hello. Hello.
Adams, Ed Levance Adams, by employment, and that's ordered the 14th day of October 2015. You see that?
Oh, he was convicted on
That's what the paper said.
The next page is going to be your indictment.
From 2012 and 2013.
This is 14 SC 130460, charging you, Mr. Bean, with those 4 counts, 2 counts of aggravated assault, possession of firearm by convicted felons, count 3, possession of firearm during the commission of a felony. This indictment was returned on October 24th, 2014. You see that?
Yeah, that's what the paper says, sir.
And underneath that, it is stamped there, October 24th, 2014, same day the grand jury returned the indictment. And if you go down, you had first, on December 22nd, 2014, entered a not guilty plea. That's on the left-hand side with your lawyer. And then in the middle of that page that Mr. Kokomo is showing, you change it to a guilty plea under Alford versus North Carolina to all counts on the first day of October, the 15th day of October, whatever that says, 2015. You see that?
Yes, sir.
And then you see underneath it's filed in the office of the clerk of Fulton County Superior Court on October 15, 2015, the same day as you were sentenced on the other September 11, 2013 crimes, right?
That's what the paper says.
And then on the next page, it shows the grand jurors charged you. And then in count 1, this indictment is only you. You're the only person in it, right?
How many times we're gonna look at it?
One more time.
How many times we're gonna keep looking at the
Still
same
does
paper?
his homework.
You're the only one charged, right?
I ain't charged. I mean, how many times we're gonna keep looking at the same paperwork that you're showing me?
You're the only one charged. Answer the question, please.
That's what the paper says.
And then it says in count 1 that the grand jury does charge and accuse Adrian Bean with the offense of aggravated assault with a deadly weapon for that said accused, County of Fulton, State of Georgia, the 7th day of September 2012.
The prosecution alleges that might have been Mr. Williams who was in the car and perhaps even pulled the trigger. Here's the thing. The only person who has a tendency to pull triggers is Mr. Bean, which goes directly against this underlying act. Oh, I hope Detective Quinn gets up on the stand. He's now retired. I hope they will call him at some point.
12, did unlawfully commit an assault upon the person of Cameron Randolph by shooting him with a handgun, same being a deadly weapon. You see that?
That's what the paper says.
Count 2 that you pled guilty to under Alford charges you with the offense of aggravated assault with a deadly weapon for said accused in the County of Fulton, State of Georgia on the 7th day of September 2012. Did unlawfully commit an assault upon the person of James Butler by shooting him with a handgun, same being a deadly weapon. You see that?
That's what the paper says.
Now, this is approximately 4 days short of a year from then, is September 11, 2013, when you were driving that red 2004 Altima, right?
I don't recall still.
The next
I don't recall still.
count is count 3, charging you with possession of a firearm by a convicted felon in County of Fulton, State of Georgia on the 7th day of September 2012, did knowingly and without lawful authority possess a certain firearm, to wit, a handgun, accused having been convicted of felony on indictment number 01 SC 03786, Superior Court of Fulton County, charge of possession of cocaine with intent to distribute on May 18, 2021, right?
That's what the paper says, sir.
That's about 11 years earlier than September 2012, right?
I guess that's what the paper say.
And you told the jurors that you've been through the prison system several times. Didn't you say that today?
Today?
Well, he certainly would say something. I mean, the prosecution doesn't object much, but I think they're getting to the 2011 case. That's the important one. There's something about that 2011 case that seems to be the important one.
Didn't you say that?
I said I've been in prison before.
All right. And then count 4 charges you possession of a firearm during the commission of a felony for that you, or it says accused, excuse me, in the county of Fulton, state of Georgia, on the 7th day of September 2012, did unlawfully have on and within arm's reach of accused a person a handgun during the commission of a felony against and involving the person of another, to wit, aggravated assault. And you pled guilty to that, right?
I don't remember.
All right. And then on the next page, it shows the witness. It shows your name and information, or some information, again, giving your date of birth as 6/22/79. And then the witness list against you. And you see that Mr. Billingsley, Mr. Butler, Mr. Randolph, and then those police officers. You see that?
Yeah, that's what the paper say.
All right. Now, Mr. Bean.
Yeah, it was something about, it was a prosecution who questioned Bean, something of the sort Mr. Queen said, Mr. Queen told. Yeah. If it was a slip up, I don't know. I'm just hoping they will actually call former Detective Quinn to the stand, because the defense has gathered so much ammunition against him. He was the lead investigator in this case. He should be the only one taking the stand. If the prosecution had chosen to just put him on the stand, not much would have changed. I mean, this specific underlying act is so bad they should have let it go.
I noticed several times on last Thursday and Friday that you were given a choice. Is your answer you do not recall information on statements that you gave on recording to Detective Quinn on September 17, 2013? Or are you saying you did not do that? Do you remember that?
Yeah, I don't recall.
And you specifically never said that you denied that it occurred. You just kept saying, I don't recall. Remember that?
That's what I said.
Now, you know and remember September 11, 2013. The I don't recall is not true. You are not being honest to the jurors. Am I right?
I don't remember, sir.
Do you recall meeting with me and investigator James Martin, private investigator? And we were trying to get in touch with you. And we caught up with you on Sunday morning, approximately 11 o'clock in the morning, on January 22 of 2023. You remember that?
Yeah, I don't really remember, though.
Do you remember saying, because we were in front of your house, I'll speak with you, but let's go to the nearby Kroger. Remember that?
Something like that. I mean, I don't really remember the conversation, though.
Do you remember Investigator Martin and me asking if we can record the conversation with you?
Okay.
Do you remember giving permission and said, that's fine?
Okay.
Do you remember me telling you, I only want the truth?
Okay.
Do you remember?
As to this.
You have an objection, Madam?
Objection as to
Basis?
hearsay, the questions have been posed.
I think he's going to ask them, so. At least, is that your intent, Mr. Steele?
I have to lay the foundation.
Your Honor, I'd like to approach us to the foundation.
Oh. The prosecution does not want this, because this recording, according to what I've heard, is him admitting that Mr. Williams was nowhere near. He just made it up. And sidebar counter 102. 41 trial days and 102 sidebars. Now, there is not as many as it was between day 1 and 25, 26. But we haven't had many long days. So if we go to complete trial days, I think we should be at maybe day 25. Maybe. Skipping ahead. Yeah, Rods. She asked for defense to lay foundation, so he's laying foundation, and she objects. Yeah. I mean, this is ridiculous. Yep. Oh, they are still on sidebar. Let's go to live. They are still on sidebar. That's a long sidebar. Mr. Jingles is playing with something or chasing something. I don't know. Yeah. Yes, my sidebar counter voice is me trying to resemble Count from Sesame Street. Yeah. I mean, this will be really damaging for the prosecution. Hello, Mr. Jingles again. If this gets admitted, even before this recording, I don't understand how the prosecution just don't leave it. We already know several police officers lied about the surveillance video. We got that entered into evidence. The traffic via the traffic radio traffic. They were committing perjury. Then former detective Velasquez admitted under oath he destroys evidence. He said that on the stand, that he can tell if a witness is lying, so he erases recordings of their statements until he gets the statements he believes is correct. Do we have a jingle counter? No, you have this thing. He's always here. Mr. Jingles is always here. I'm just doing here I'm here as a spokesperson for Mr. Jingles.
Ladies and gentlemen,
Thugs.
oh, it's not church yet. Come on now, stop fanning, all right? Okay, all right. Not that hot. All right, ladies and gentlemen, we are going to take a comfort break, and then we're going to go ahead and take lunch, okay? So we'll come back for 2 o'clock. We're going to go about an hour at that point in time, and then that'll be the, I'll make some administrative announcements at that point in time, okay? All right. So remember the admonitions I've given you. Enjoy your lunch. We'll see you back at 1 o'clock. I mean, I should say 2 o'clock, okay? All rise.
That means we are at least on a 90-minute to 2-hour break.
There you go.
Seriously? What in the actual... If it's just an
Oh my
hour,
God. Enjoy it.
ask, do you want to skip lunch so you can get home earlier? For fuck's sake.
I could have. I
Actual,
could have eaten those all afternoon.
yeah. In the beginning of this, I actually had an FFS counter.
All right, ladies and gentlemen,
I
please be
lost count.
seated. The door, Deputy, can you get Mr. Bean, please, sir?
Oh, hearing.
Thank you.
They will have a hearing about this recording outside the presence of the jury. Okay, so no actual break. Yes, Ghostry, I am occupying Mr. Eagle's chair.
Mr. Bean, just hold fast, stand fast. I'm going to release you for lunch. Come back for 2 o'clock.
Oh,
I'll be back here just a little before 2. Don't discuss testimony with anybody except the attorneys in this case, okay? Okay, see you then. All right.
the appeal Mr. Steele sent to the Supreme Court.
Counsels, we're gonna be in recess.
I think I have those documents somewhere. And since they are taking a break after today, I will find time to go through those appeals, I hope. Yes, I know it's about the indictments. If I find the time, I will.
Until 2 o'clock. Can I see Ms. Love and maybe Mr. Steele and Mr. Matthews? Can you all come up for a second, please? All right, we're in recess.
No. Oh, why don't... if it's that important, it should be on the record. Here's what we're going to do. I can't do 90 minutes on this. I mean, I can try to occupy time for 90 minutes, but I don't see why. Because it's just a waste of everybody's time. So what we are going to do, I will do the final hour, if there is one. We really don't know with this judge. I will do that tomorrow before Jodi Day. Tomorrow at noon Eastern time, it is me and Dave are reading from Jodi Arias' manifesto, quote, in case she becomes famous. If you don't know who Jodi Arias is, she is the original Amber Heard. No, yeah, all the letters in the alphabet, and she was convicted of the murder of Travis Alexander in 2013, and she avoided the death penalty with 1 vote from one juror. So we are revisiting that and reading from her manifesto. Yeah, but 90 minutes. I mean, I just can't. That's a bit too long. Had they had a hearing now or something of the sort, but instead he chooses to waste everybody's time again. So what we are going to do is, I am checking right now for that would be worst judgment he can make now is disregard the entire testimony. I don't think, yeah, that's an actual possibility. I don't think so. No, I don't think so. Don't know what the ruling will be on the recording. I hope it will come in. I really do. I don't really see a reason why it shouldn't. But you never know with this judge. I stopped being surprised a long time ago. Long time ago. Oh, what can we do? I'm going to send you over to Dani Ahn. She's covering the Rust shooting trial. Are we seeing how adorable Mr. Jingles is present? Yes, here he is. Hello. Hello. Hello, Mr. Jingles. Are you having a good time? You have gunk in your eye. I'm going to remove that. I just need to dress up in Kevlar first because you shred me to pieces every time I try to do it. All right. I'm going to send you all off to Dani Ahn doing the Rust shooting trial against Hannah Gutierrez-Reed. All right. Thank you all for being here. Thank you for giving me all the thumbs up and everything. Thank you for the super chats and everything. Thank you for allowing me to try to translate this trial to you, for being here day in and day out. Now, we will see each other again tomorrow for the final hour of this, then Yodi Day. And thank you for... I don't want a cat's asshole in my... Yeah. And, as I always say, hug your family. Unless your family is shit, then fuck them and give your love to the people who deserve it. Okay. See you tomorrow. Bye-bye.